Mr. Leedy, good morning.
Good morning, Your Honors. May it please the Court, along with Attorney Joseph Cataldo, I represent the appellant, Dennis Bauer. This matter presents a relatively limited question to this Court, specifically whether the legislature's delegation to the judiciary pursuant to General Law, Chapter 90, Section 24(1)(f)(1), allowing the judicial branch to review a license suspension by the registry pursuant to the failure to take a breathalyzer violates the provisions of Article 30.
But the legislature says that the suspension of the license is mandatory in this situation, correct?
Correct.
So it's not a well, there's two problems, I think. It's not a discretionary decision of the registry, has to happen by law, and the law itself says the judge is the one who's going to decide whether to give it back on acquittal or not.
If I can address the two portions. The first is, certainly the legislature has the authority to, in some senses, delegate or restrict the parameters that an administrative body can consider by law.
Since the legislature sets up an administrative body, I would say that that's probably true.
Correct. So the first instance of mandating to the registry that there is no discretion to be regarding the suspension, assuming that, one, the suspension was related to an operating under the influence. In other words, that the officer wasn't simply randomly asking motorists. And the other two provisions regarding that there was an arrest and there actually was a refusal. Yes, that is the dictate of the legislature to the registry that in these circumstances you have no discretion and you must suspend the license.
Right.
But the second portion of that places the judiciary branch in the position of assessing whether an operator for a motor vehicle can do so safely, whether the operator is likely to endanger the public, that whether that restoration of that license is likely to endanger the public. And it's that question, the likely to endanger consideration, which is something which lies exclusively within the registry.
Why?
Not if the legislature has said it's a judicial decision.
But what the legislature is setting up is a judicial review of a registry suspension.
No, it's not. It's saying that there's an escape valve. And we're going to let the judge, rather than the legislature, decide if there's an escape valve. One reason why you may want to do that is because judges are accustomed to hearing evidence and, resolving conflicting testimony, and that's what judges do all the time. And we're not going to waste the legislature's time with having to set up administrative hearings. That's not what the legislature does.
But what it does is it is giving the judiciary the consideration of, it's the likely to endanger consideration, which is something which relies solely within the registry. Because the registry is the administrative body set up by the legislature to determine whether individuals should be licensed within the state.
But except in certain circumstances that the legislature says, we think this is a little subclass that can go over to the judiciary. Why is that a violation of Article 30?
Because, Your Honor, it's the subclasses that are strictly limited by time and circumstances. Specifically, Your Honor, this language that was placed into Section 24, I'd suggest, comes right out of Section 24N.
Right.
Under 24N, where a police officer does not act in behalf of the registry in seizing a defendant's license, in filing a notice of suspension with the registry upon an arrest and refusal to take a breathalyzer, where the police officer does not act in that circumstance, the judiciary has the ability to, for a small, definite period of time, issue a suspension of that license as the statute states, in addition to any other terms or considerations of bail or recognizance. I'd suggest to the Court that what was considered by this Court in Crowell, in a very small portion of Crowell, which simply states that that is a judiciary function, is there because, one, that is a limited circumstance. It's a backstop to the failure of a police officer to take action.
Isn't another way to look at it is that the Court was saying it's a judicial function because the legislature said it was, because they said it is the judge's responsibility to figure that question out, which is the same here.
Well, it's the judge's function to automatically suspend that license, just as a police officer would be required to do so with the registry. That court's then consideration under 24N of its own order, under the same terms that are placed within 24(1)(f)(1), is a review of that determination made by the judiciary subject to or in conjunction with the other terms of bail or recognizance that are then issued by the court. So it's a limited circumstance with the court reviewing its own order, with that order being pegged to issues of bail or recognizance as contained within 24N. And the period of time is limited.
Mr. Leedy, which provision of Article 30 are you relying?
Your Honor, I believe if it was stated correctly in the defendant's brief, I'm relying on the portion that indicates the executive shall not exercise the legislative judicial powers of either of them, and the judicial shall never exercise the legislative and executive powers or either of them.
Well, which power is the executive exercising?
The executive, Your Honor, the power of the executive would be, again, back to the registry as an administrative body of the executive branch.
Which legislative and judicial powers is the executive exercising?
No, his argument is that the judicial power is exercising executive function.
I asked him which provision, and he said both. So,
It's the judicial, Your Honor. I apologize.
okay.
It's the judicial function exercising that executive power falling within the registry as the administrative body under the executive branch.
Could I ask you this question? Assume hypothetically that we were to disagree with your Article 30 analysis. You don't challenge the substance of the judge's decision, is that correct?
I don't, Your Honor, at least for terms of this appeal. I think it was an issue that was addressed below. However, given its preponderance of the evidence standard and given I think the breadth of information presented by the Commonwealth, that issue wasn't presented to this court as part of this appeal. Solely whether the actual act of the court in suspending that license was sufficient.
Thank you, Mr. Leedy.
Thank you, Your Honor.
Ms. Johnson.
Thank you. May it please the Court, my name is Melissa Johnson. I'm an Assistant District Attorney in Middlesex here on behalf of the Commonwealth. And there are a variety of reasons why the separation of powers does not prohibit the legislature from giving the judiciary the authority in the specific instance of restoring a license after a not guilty finding here. I'm not going to go through all of them. They're in my brief. I'd like to focus on the analogy between this statute, 24(1)(f)(1) and 24N, and also the policy reasons behind it. As you know from the brief and from the statutory construction here, 24N is virtually identical to 24(1)(f)(1), which is the statute at issue in this case. And this court has already examined 24N and deemed it to be constitutional and deemed it not to violate the separation of powers. And I bring that up because the only difference between those two statutes is when the license is pulled, when it is suspended. The first, in 1F1, it is the officer that takes it. In 24N, it is the court that takes the license if it has not been already taken by the officer. But in both statutes, the means for the restoration of the license is the same. It is the judiciary, it is the judge who, after a not guilty finding, at that point, the driver can apply to have his license reinstated, and it's up to the judge to determine, with a rebuttable presumption in his favor, whether the Commonwealth has met its burden by a preponderance of the evidence in proving that the driver will pose a threat to public safety. In that case,
this
yes,
is just
Ron.
a factual question. Under 24N, if a judge pulls the license, that's also mandatory, isn't it?
Well, there is a little bit of a review. The judge does have to determine, for example, the judge can pull the license if there is a breathalyzer of equal or over 0.08 or if the driver has refused the breathalyzer. And there is a little bit of a factual determination as to what has occurred below, but essentially,
But if one of those occurred, the judge doesn't have discretion to say, well, not in your case, I'm not going to do that.
right, as long as the Commonwealth has provided a prima facie case, yes. So in that instance, then, in 24N, after a not guilty finding, a judge will go through the same exact questions, determination, as would he or she in 24-1F1 if the license has been pulled by the officer and the person has refused a breathalyzer in that case. So in both instances, this court in Commonwealth versus Crowell went through the examination of whether that violates separation of powers and concluded that it did not. And there's virtually no difference between these statutes. My brother brought up the argument, well, the court is reviewing its own order in 24N and not in this case. The court would be reviewing the order of the RMV, but it's really a distinction without a difference because in the initial instance, it is a mandatory suspension of the license. There's not really much to review there. So it doesn't really matter if it was originally pulled by the RMV or by the court.
I think what you're really saying is it's not a review at all. It's a determination whether, in the circumstances, the license should be returned.
Right. And in this case, the legislature has, as the court had examined in Crowley, the legislature has created a specific situation where the judge can make that determination after a not guilty finding. It's a specific situation where it has delegated that authority to the judiciary. And it makes sense from a policy perspective. From number one, it's the same judge who presided at the trial, so he or she is already familiar with the facts instead of sending it back to the RMV. And the second reason is because in this instance we have a situation where a license has been revoked because the offender refused the breathalyzer, which is really separate from the underlying OUI drunk driving charge. It's not the criminal aspect of it. This is the public safety aspect of that law. So the statutory landscape here really makes perfect constitutional sense. If the license has been originally suspended because he refused a breathalyzer test, it really doesn't make a lot of difference whether there's a guilty or a not guilty at the end of the OUI trial. This question still remains, is this person who has his license suspended for refusing a breathalyzer, does he still or she still pose a public safety risk? It's a determination that still needs to be made, whether or not the outcome of that criminal trial. There are two separate lines here. And so it's important to keep that policy perspective in mind, in addition to the legal perspective that Crowell and Bratch have dictated that the legislature can determine who has the authority to suspend in this case. There's also the policy behind this implied consent law. It makes perfect constitutional sense why in this instance the legislature has determined that the court is in the best position to determine whether this guy should get his license back, not necessarily the RMV. If there are any further questions, I would be happy to rely on my brief
Thank you, Ms.
for the remainder of
Johnson.
my argument. Thank you very much.